Recently, the Utah Court of Appeals issued its decision in the criminal prosecution matter of State v. Smith, and its application to family law should be apparent when I quote to you the first and last paragraphs of the decision. That citation to the full decision is State v. Smith, 2024 UT App 82. And I have provided a link to the full decision in the description section of this video if you want to read it. Quote, after coming home from work, Shawntell Smith, Shawntell, gathered her family as she had planned and calmly told her husband of nearly 30 years, Stephen Timothy Smith, that she was leaving him and taking their kids with her. Over the next 25 minutes, Smith left the house, drove to the bank, and withdrew $15,000, returned home and put the cash in a drawer, got his gun from the closet, and loaded the magazine, and asked his two sons if they agreed with the plan to move out. He then fatally shot Shawntell 7 times in the back as she stood in the kitchen. At trial, Smith confessed on the stand, and a jury convicted him of first-degree murder. Smith challenges his conviction on the grounds that the trial court erred in denying his request for a jury instruction on the defense of extreme emotional distress, or EED, and in denying his last-minute motion for a continuance to hire an expert witness. We reject both of Smith's arguments and affirm his conviction." Close quote. Now here's the last paragraph. Quote, Shawntell's calm announcement to Smith that she was leaving and taking the kids with her did not constitute the, quote, highly provoking act, close quote, required for an EED defense, and in any event, it did not occur, quote, immediately preceding, close quote, Smith's fatal shooting of her. Therefore, the trial court did not err when it declined to instruct the jury on the EED defense. The court likewise did not abuse its discretion when it denied Smith's last-minute motion for an expert witness to assist in presenting that defense. Accordingly, we affirm Smith's conviction.